Everyone, welcome to the channel. Now we have reached to parts of 31, section 31A, 31B, 31C, and 31D, which are emphasized as saving of certain laws. 31 reads as Clause 1, notwithstanding anything contained in Article 13, no law providing for A. The acquisition by the state of any estate or of any rights therein, or the extinguishment or modification of any such rights, or B. The taking over of the management of any property by the state for a limited period, either in the public interest or in order to secure the proper management of the property. Or C. The amalgamation of two or more corporations, either in public interest or in order to secure the proper management of any of the corporations. Or D. The extinguishment or modification of any rights of managing agents, secretaries, and treasurers, managing directors or managers of corporations, or of any voting rights of shareholders thereof. Or E. The extinguishment or modification of any rights accruing by virtue of any agreement, lease, or license for the purpose of searching for or winning any mineral or mineral oil, or the premature termination or cancellation of any such agreement, lease, or license, shall be deemed to be void on the grounds that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19, provided that where such law is made by the legislature of a state, the provisions of this article shall not apply thereto unless such law, having been reserved for the consideration of the President, has received his assent. Provided further that where any law makes any provision for the acquisition by the state of any estate, and where any land comprised therein is held by a person under his personal cultivation, it shall not be lawful for the state to acquire any portion of such land as is within the ceiling limit applicable to him under any law for the time being in force, or any building or structure standing thereon and pertinent thereto, unless the law relating to the acquisition of such land, building, or structure provides for payment of compensation at a rate which shall not be less than the market value thereof. Clause 2 states that in this article, subclause A, the expression estate shall in relation to any local area have the same meaning as that expression or its local equivalent has in the existing law relating to land tenures in force in that area, and shall also include first any Jagir, Inam, or Muafi, or other similar grant, and in states of Tamil Nadu and Kerala any Janmam right. Janmam right. Second, any land held under Ryotwari settlement. Third, any land held or let for purposes of agriculture or for purposes ancillary thereto, including wasteland, forest land for pasture, or sites of buildings and other structures occupied by cultivators of land, agricultural laborers, and village artisans. Subclause B, the expression rights in relation to an estate shall include any rights vesting in a proprietor, subproprietor, underproprietor, tenure holder, rayat under rayat, or other intermediary. Rayat under rayat means rayat is the zamindar, is the landholder, is the tenant. So tenant under tenant, it means. Rayat under Rayat or other intermediary or and any rights or privileges in respect of land revenue. Article 31B, validation of certain acts and regulations. This is the title, which is written on the sideline, if you can see. And 31B states that without prejudice to the generality of the provisions contained in Article 31A, none of the acts and regulations specified in the ninth schedule, nor any of the provisions thereof, shall be deemed to be void or ever have to become void on the ground that such act, regulation, or provision is inconsistent with or takes away or abridges any of the rights conferred by any provisions of this part, and notwithstanding any judgment, decree, or order of any court or tribunal to the contrary, each of the said acts and regulations shall, subject to the power of any competent legislature to repeal or amend it, continue in force. 31C, titled Saving of Laws Giving Effect to Certain Directive Principles. 31C states that notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the grounds that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19, and no law containing a declaration and no law no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy, provided that where such law is made by the legislature of a state, the provisions of this article shall not apply thereto unless such law, having been reserved for the consideration of the President, has received his assent. 31D was repealed by the 43rd Amendment Act in respect of anti-national activities. Now, for the understanding of 31A, you should stay with me. Understanding of 31A. So, 31A was added by the Constitution's First Amendment Act, 1951. Let's get back here. 31A was added by the Constitution's First Amendment Act, 1951, in order to provide protection to Zamindari abolition program launched by the central government and to acquire lands of zamindars. This was the first constitutional amendment. This article states that no law providing for the acquisition by the state of any estate or of any rights therein or for extinguishing or modifying any such rights would be void on the ground of inconsistency with any of the fundamental rights contained in Article 14 and Article 19. Earlier, 31 also mentioned here, but the same was repealed by the Constitution 44th Amendment Act. 31 Article 13(1) was related to right to property, which is now 300A. Object of Article 31A were mentioned in KK Kochuni versus State of Madras, AIR 1960. The Supreme Court held that the protection of Article 31A is not applicable to a law which seeks to modify the rights of the owner without any reference to agrarian reforms. Secondly, in the case of Bhagat Ram versus State of Punjab, AIR 1967, the Supreme Court stated that a person who is cultivating land personally and it is his source of livelihood should not be deprived of that land under any law protected by Article 31A unless compensation at market rate is given. Furthermore, in the state of Kerala versus Gwalior Rayon Silk Manufacturing, AIR 1973, the Supreme Court held that there has to be a direct nexus between the subject matter acquired and its utilization for agrarian reforms. About the constitutional validity of Article 31A, it was said in Ambika Mishra versus State of Uttar Pradesh, 1980. The Supreme Court held the constitutional validity of Article 31A, subclause 1, subclause A, on the test of basic structure. Article 31A, clause 1, subclause A, the acquisition by the state of any estate or of any rights therein or the extinguishment or modification of any such right. And further, in the case of Minerva Mills versus Union of India, 1980, the Supreme Court held that whole Article 31A is unassailable on the basis of stare decisis, a quietus that should not be allowed to be disturbed. About Article 31B, which is mentioned here, the validation of certain acts and regulations. About that, 31B was added by the Constitutional First Amendment Act 1915 with a view to protect the specified statutes from attack on the ground that they infringe any of the fundamental rights enshrined in Part 3 of the Constitution by putting such statutes in ninth schedule. The term ever to have become void used in the provision clearly indicates that it has retrospective effect. The ninth schedule contains 284 legislations. Laws included in ninth schedule are these are talked about in Vaman Rao versus Union of India, AI in 1981. The Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the ninth schedule. All the acts and regulations which are or will be included in ninth schedule on or after 24th April 1973 will not receive the protection of Article 31B. Furthermore, in the case of IR Coelho versus State of Tamil Nadu 2007, also known as the ninth schedule case, a nine-judge bench led by the then Chief Justice Sabharwal of Supreme Court held that the laws included in ninth schedule before the decision of Keshwanand Bharati case are immune, but the acts included after the decision shall be open to be challenged on the grounds of violation of fundamental rights. The Supreme Court further reaffirmed that Article 31B did not destroy or damage the basic structure of the Constitution. So, this was approved by the Supreme Court, this article. About 31C, no, one clarification is that all or any of the principles laid down in Part 4, all or any of the principles laid down in Part 4 have been declared unconstitutional. So, in reality, it is the principles specified in Clause B or Clause C of Article 39 and 31C. Therefore, readers are requested to take special care of this fact, otherwise, one will have wrong idea of Article 31C. About the 25th Constitutional Amendment Act 1971, Article 31C was inserted by the 25th Constitutional Amendment Act 1971 with a view to provide immunity to any law enacted for implementing the directives in Clause B and C of Article 39 from any challenge on the ground of violation of Article 14, 19, and 31. It was also provided that such law would not be open to judicial review. However, the second part, which took away the power of judicial review of the court, was held to be unconstitutional and invalid in the case of Keshavan Bharati versus the state of Kerala, AIN 1973, SC 1461. So, you should remember the fact that the second part, which took away the power of judicial review of the court, was held to be unconstitutional. So, this ninth schedule, which took away the power of the court of judicial review, was held unconstitutional and invalid in the case of Keshavan Bharati. Now, through the 42nd Constitutional Amendment Act 1976, through this amendment, the Parliament inserted the words all or any of the principles laid down in Part 4, DPSP, Directive Principles of State Policy, in place of Clause B and C of Article 39. Thus, this amendment provided immunity to the laws enacted for implementing all or any of the principles laid down in Part 4 from any challenge before court on the basis of violation of Article 14, 19, and 31. But the validity of this amendment was challenged in Minerva Mills versus Union of India, AIR 1980, and it was held to be unconstitutional. Thus, Article 31C is confined to its pre-96 position, 1976 position. The court further held that Indian Constitution is found on the bedrock of the balance between Part 3 and Part 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. The harmony and balance between fundamental rights and directive principles of the state policy is an essential feature of the basic structure of the Constitution. The same view has been reiterated by the Supreme Court in Sanjeev Coke Manufacturing Company versus MS Bharat Cooking Coal Limited, AIR 1983, and stated that 42nd Constitutional Amendment Act 1976 destroys the basic feature of the Constitution and thus unconstitutional. The court held that 31C has originally introduced by the 25th Amendment Act is constitutionally valid. 44th Constitutional Amendment Act 1978, this amendment substituted Article 14 or Article 19 in place of Article 14 or Article 19 or Article 31 because Article 31 has been repealed by the 44th Constitutional Amendment Act, which was right to property. If you remember, I've already made a video about it. Article 31, which was repealed by the 44th Constitutional Amendment Act, it was given the fundamental right of property, right to property.